All right, good afternoon, everyone. I am so excited to welcome you all to our 5th Constitution Day event, sponsored by Attorneys for Civic Education and the Idaho Law Foundation. For my students who are in the room, who I still have a little bit of power over, you see our Attorneys for Civic Education logo up there. I always wear this blue dress as a reminder because it's a circle and it's blue, to get involved with civics education. We have lots of programs that we can use you to support. I also want to welcome our high school students from Boise High School. Thank you to Mr. McMorrow from Boise High, and our students from McKenna Charter, Ms. Hodek, who tells me Ms. Triska is responsible for doing all the coordinating events to get you guys here. So welcome and thank you so much for attending. And also thank you to our attorneys and students and lawyers and retired justices and judges and all the folks in the room and then the folks online as well. I'm Jessica Lorello, by the way. Judge on the Idaho Court of Appeals and an original member of Attorneys for Civic Education. So it is my honor to introduce our keynote speaker today, Professor Neil Siegel. He is a professor of law and the co-director of the Center on the Structural Constitution at Texas A&M University School of Law in Fort Worth, Texas. He is also professor emeritus of law at Duke Law, go Devils, in Durham, North Carolina, where he taught for 21 years and continues to teach at the Judges, and I meant to ask you this ahead of time, is it Bulch Judicial Institute's Judicial Master's Program. Professor Siegel is a constitutional law generalist. His scholarship addresses a variety of areas of constitutional law, and in doing so, he considers ways in which a methodologically pluralistic approach can accommodate changes in society and the needs of American governance while remaining disciplined and bound by the rule of law. He was also a law clerk for the United States Supreme Court, as well as an author of the Collective Action Constitution for any of you constitutional law nerds like me. We've also had the privilege for many years of having Professor Siegel come to the Judicial Conference, which is also going on this week, where he basically does a Supreme Court case law update. So please help me welcome Professor Siegel to the podium.
Well, thank you for that very generous introduction. I've been coming to Idaho for around 20 years now to address the state judiciary, as you just heard, but I've never been in this venue for this event with all of you folks, and I'm honored to be here. My charge is to speak for about an hour and then leave time for questions. There's so much going on in the world these days that we could just go straight into the questions, but I wouldn't be doing my job if I did that. It's a difficult challenge, at least if you're a speaker who cares about who's in the audience, and I am such a speaker. It's a difficult challenge to speak to judges, lawyers, and high school students all at the same time. I'm going to do my best to be accessible to everyone. Where I don't succeed, it's my failure, not yours. I can remember what it was like to be in high school and to go to an event like this. It wasn't in Boise, it was in Long Island, New York. And I thought, well, the plus side is I get to get out of class. The minus side is I got to listen to somebody talk for an hour. And so I'm going to do my best not to bore you to tears if this subject is not near and dear to your heart as it is to me. A recent Solicitor General of the United States, Elizabeth Prelogar, went to Boise High School from these parts, and she is an extraordinarily gifted Supreme Court advocate. And so if this subject does end up interesting you, well, you wouldn't be the first one from around here to go off and do great things in Washington, D.C. General Prelogar wasn't the first one either, but she's a recent shining example, and I hope you all are very proud of her accomplishments. All right, so and I'm going to put my glasses on now, not to convey just how much older I am than most of you, but because I've recently had eye surgery, and so now I have vision that is perfect from distance, like better than when I was in high school, but I can't see anything up close, whether it's a phone or my notes, without my glasses. And therefore, I'm going to do this. This is my secret weapon. Okay, so the subject of my remarks today is how the Supreme Court historically has responded and responds today when it is under political threat. And by political threat, I don't just mean criticism, people being unhappy with the Supreme Court. That happens all the time. I mean a real risk, a viable chance that a powerful politician, a president, a governor, a state legislature will defy a Supreme Court decision or order, or a real risk that Congress will punish the court in various ways. It could take away most of its jurisdiction to hear cases. Lawyers call that jurisdiction stripping. It could add seats to the Supreme Court in an effort to seize ideological control of the institution. That's called court packing. The title of my talk is The Supreme Court Under Threat: Early Lessons in Judicial Self-Protection. I'm going to talk about history, but I'm also going to talk about the present moment, because history may not repeat itself, but it often rhymes, as a famous person once said. History done well is fascinating. It teaches you how to think for yourselves, how to think analytically, how to think like a lawyer. History done poorly is awful. Someone is making you memorize dates and regurgitate them on an exam. That's not history, right? That's something you can train someone who doesn't need to be in school to do. And so I'm going to use historical materials, because to do law is to think in part historically. But make no mistake, this is not just the past for its own sake. It's also relevant to what's going on in our world today. My remarks derive in large part from my own research that I'm doing with a colleague and friend of mine, Curtis Bradley of the University of Chicago Law School. We're working on an essay for a symposium that my center, the Center on the Structural Constitution, is co-hosting with the Harvard Law Review. We're going to have a conference there next month on whether judicial review is in jeopardy in contemporary times. And a methodologically, ideologically diverse group of law professors are going to gather at Harvard to talk about strains on the judiciary in the situation that we're facing today. And so this topic is much in the news, it's much in the minds of law professors as well. We're running an essay that will be published in the Harvard Law Review in the spring. If you have an interest in it and in the topic that I'm talking about today, send me an email. I'll be happy to share it with you. nss12@law.tamu.edu. That's nss12@law.tamu.edu. I'm happy to share my work in progress with you. So the Supreme Court of the United States is both the most powerful court in the world and the least dangerous branch of the U.S. government. Because the Supreme Court is powerful, it's largely able to execute its legal responsibilities. Because it is a court, I dare say only a court, because it lacks either the sword, which belongs to the president, or the purse, which belongs to the Congress, it is vulnerable to being defied successfully by presidents in states and to being punished by Congress. I will attempt to persuade you that the Supreme Court has become powerful despite being institutionally vulnerable, because it has learned some things through hard experience. It has learned to perform two roles reasonably well. The first function is legal. The court is the primary guardian of the Constitution and the rule of law in the United States. It wasn't inevitable that it would end up that way. Other democratic societies may have other institutions that are primarily responsible for maintaining the rule of law. But in our country, given our history, that function has descended primarily upon the Supreme Court. The second part played by the court is political. although not in the sense of pursuing policy preferences or ideology, let alone partisan politics. It's political in a different sense. The court must survive in a world in which it ultimately must persuade powerful politicians to abide by its decisions, and in which it ultimately depends upon the executive branch, the president, to enforce its decisions. The Supreme Court can't enforce its own decisions. It has a small police force. They protect the justices and the building. They can't go out and enforce Supreme Court decisions. In short, the court has two central tasks, especially when it is under political threat: preserving the Constitution and the rule of law, and protecting itself. In my judgment, legal scholars and lawyers who believe that the court should focus exclusively on the first, legal function, fail to sufficiently appreciate the reality that the court does not just act in the world. It can also be acted upon or ignored. As I will show, the court began learning how to play both roles early on. The court made itself available to interpret and apply the law as Article 3 of the Constitution, the Judiciary Article, as well as the Judiciary Act of 1789, the first federal statute that organized and empowered the federal courts, instructed it to do. But the court soon learned that it could not continue performing this role if it developed no way of practicing self-protective politics. I'll begin by identifying various devices that the court has developed over time to navigate difficult situations, including, I would say, the current one. I will then examine an episode way back in American history, back in 1803, near the beginning of the nation's existence under the U.S. Constitution, in which the court successfully navigated existential threats to its continued authority. Existential means threatening its very existence as an effective governmental institution. Two cases from 1803, Stewart v. Laird and Marbury against Madison, both arose out of what I call the Jeffersonian backlash against the judiciary after the historic elections of 1800. I'll then conclude by offering a qualified defense of the court's uses of what I call the tools of judicial self-protection, despite the potential costs of such use. Life is complicated. Law is complicated. The stuff I'm going to talk about is controversial, both in general and in particular applications. There are costs associated with the court behaving in the way that I think it tends to behave when it's under pressure, and in a way that I'm prepared to defend, although not without qualification. All right, before beginning, I want to offer two important caveats or qualifications. First, I'm distinguishing, for purposes of analysis, the court's tools of judicial self-protection, the court's practice of a certain kind of politics on the one hand, and the court's view of what the law requires it to do on the other hand. But in practice, I want to recognize that this distinction will blur at the margins because it turns on the motivation of at least the majority of the justices. For the court to act, almost always, it needs at least the majority of the justices to sign on. And judicial motivation can be difficult to discern for a number of reasons that I'll discuss. Some of the tools, like limits on the court's jurisdiction or authority to decide cases, are rooted in legal materials, even if they have discretionary elements to them. And so what might look like an effort at judicial self-protection could simply be an application of the law. In drawing the distinction between self-protection and legal analysis in the 1803 episode that I'm going to examine, I rely on private statements of the justices involved, what they really thought, as opposed to what they put in their judicial opinions, the assessments of historians and legal scholars who've studied the episodes and drawn certain conclusions about what was likely motivating the court at the time, as well as my own analysis of the relevant legal materials and my own judgment about how plausible the court's legal reasoning and conclusions were. This distinction I draw between self-protection and doing law, legal analysis or legal interpretation, can also become blurry in the opposite direction. That is, decisions on the merits by the court could themselves be responses to political threats. For example, to avoid a confrontation, the court could simply adopt an interpretation of the law that upholds presidential or congressional action, basically pleases the source of the threat against the court. But from the court's perspective, the advantage of using the tools that I'm going to describe is that they involve less of a long-term concession of power by the court. In the episode I'll discuss, the court seemed to be trying to avoid making long-term concessions while still protecting the institution, still watching its back, if you will. My second caveat before beginning is that even when the court is not under threat, it uses a variety of tools and techniques to preserve and enhance its authority. These tools include following its own prior decisions much of the time. Lawyers call this stare decisis. Issuing majority opinions, opinions of the court, as opposed to what lawyers call seriatim opinions, opinions by one judge after the other, and then the reader has to add it all up to try and figure out where the court came out. They used to do decision-making that way. The justices wear robes. They hear arguments in an ornate courtroom. They sit in a magisterial building, not so unlike this one. The court's building has large white columns. These practices express messages. They convey meanings. There are reasons why the buildings we occupy oftentimes look the way they do. It's worth paying attention to that. These practices are beyond the scope of my talk today, but I want to acknowledge that they're related to it as well. All right, the tools of judicial self-protection. Let me motivate this discussion by giving you my sense of the position of the Supreme Court during the second administration of President Donald Trump. I think the court has been in a difficult position. The Trump administration has taken aggressive actions and legal positions against a wide variety of individuals and entities. Lower federal courts have responded unfavorably to many of Trump's initiatives. And when these courts have ruled against him, Trump has sometimes accused the judges of endangering the country. And some of his supporters in Congress have called for the impeachment of these judges for the imposition of major restrictions on federal judicial power. So the relationship between the administration and the federal courts since the second Trump administration began has been strained. I don't think these have been typical, ordinary times in terms of judicial executive relations. Trump himself called for the impeachment of the chief judge of the federal district court in Washington, D.C., James Boasberg. He had temporarily barred the government from deporting certain non-citizens. And at that point, the Chief Justice of the United States, John Roberts, intervened and issued a rare public statement. For more than 2 centuries, Roberts observed, without mentioning Trump, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. That's what Roberts said in a public statement. Since then, there have been instances in which the Trump administration has failed to comply with judicial orders of the lower federal courts. I'm thinking of 2 cases in particular that I'll talk about tomorrow with the Idaho judiciary, Trump against JGG and DHS against DVD. And there's been at least one instance in which the administration arguably did not comply in full good faith with an order of the Supreme Court itself. I'm thinking about one of the cases involving the Alien Enemies Act, a once obscure federal statute that I'll talk about in a little bit. Relations between the federal courts and the executive branch became sufficiently strained in one case that a prominent conservative appellate judge for whom I once clerked, J. Harvey Wilkinson III of the U.S. Court of Appeals for the Fourth Circuit in Richmond, Virginia, he refused the Trump administration's request to reverse a district judge and warned that if the administration continued to construct a regime of what Wilkinson called perfect lawlessness by flouting the law, quote, the executive may succeed for a time in weakening the courts, but over time history will script the tragic gap between what was and all that might have been, and law in time will sign its epitaph, end quote. Wilkinson is a former journalist and puts a premium on clear, effective, powerful writing, as I learned from him yelling at me for a year when he didn't like drafts that I produced. But that's quite a statement from someone who was on the short list for the Supreme Court twice and interviewed at the White House for President Bush the first and President Bush the second. He came this close to being on the Supreme Court. A funny story, he used to run every day at lunch and kind of encouraged, we'll say, his clerks to run with him. It didn't matter if it was 100 degrees with 100% humidity in Charlottesville. And I encouraged the judge to maybe do some cross-training to mix in the running, mix it up a little. And he yelled at me and said, I don't need a mother, I need a clerk. So then he goes to the White House and interviews with President Bush II. And what did I read in the New York Times? That the president took umbrage that he only runs Wilkinson and doesn't cross-train, or something to that effect. So I didn't have to say I told you so, but I did. Anyway, sources of the court's authority. So I understand that many folks in the room just read Federalist 51, right? The basic lesson is that you really shouldn't put all power in the same hands. If they're not your hands, and frankly, even if they are your hands, because you shouldn't entirely trust yourself with power, trust no one with power, let alone all the power. And that's the point of Federalist 51, right? The great security against a gradual concentration of all the powers in the same department, consistent giving to those who administer each department the necessary constitutional means and personal motives to resist encroachments of the others. And on, ambition must be made to counteract ambition, right? Well, there's another Federalist paper, 78, in which Alexander Hamilton observed that the federal judiciary, unlike the political branches, has, quote, no influence over either the sword or the purse, no direction either of the strength or of the wealth of the society, and can take no active resolution whatever. Hamilton said that the judiciary, quote, may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, the president, even for the efficacy of its judgments, end quote. And so the court is institutionally vulnerable, is what Hamilton was saying, and what I've already said. And given that vulnerability, there's a puzzling question that arises. Why do powerful politicians, why do presidents in particular, given the status and power of the modern presidency, regardless of who's president, executive power has been expanding by leaps and bounds since the dawn of the 20th century. Back when the Constitution was being written and the Federalist Papers were being written, they were worried about Congress, the first branch, overwhelming all the other branches. That's why they broke Congress in two and gave the president the veto power. Times have changed in ways our founders did not anticipate. Why do presidents typically obey judicial rulings that disallow or limit their actions? It's a remarkable thing for a court to issue a decision and for the litigants to comply voluntarily and for the executive to enforce the decision if enforcement is necessary. It's a crucial way in which we settle disagreements non-violently, peacefully for the time being. That's not how disagreements are settled in societies around the world or in this country at certain points in American history. We settled the issue of slavery in the territories through the barrel of a gun, through an epic, savage civil war that killed 2% of the American population. So we shouldn't take this for granted, that courts decide cases, and even the President of the United States typically obeys. Scholars have identified a number of likely reasons, each of which depends on the circumstances. First, because of tradition, socialization, and legal training, norms of compliance with judicial orders usually permeate the executive branch. But the Trump administration is notorious for disregarding traditional norms of government behavior. Its supporters applaud this, its critics object, but I don't think there's much question that the president does not have a lot of use for traditional norms of government behavior. Second, there will typically be political costs associated with defying judicial orders. The public doesn't tend to like it when presidents disobey Supreme Court decisions, for example. But these costs depend upon congressional and public support for the judiciary, which cannot always be taken for granted. In addition, it's not hard to imagine situations in which a president, any president, might conclude that the political costs are outweighed by the benefits of noncompliance. Third, presidents generally benefit from a strong judiciary. A strong judiciary is useful to the president. Among other things, federal courts help the executive branch do different things, enforce federal law, legitimate some of its controversial actions, resolve controversial issues that fracture a president's coalition, pass the buck, right? Pass the hot potato, let the courts decide the matter, provide insurance against future political harm when the president's party loses power, is out of office. Courts protecting rights, right, are good for those who lose the most recent set of elections. But there's no guarantee that a president is going to care about any of these things more than he's going to care about getting the courts out of his way. Whatever the exact reasons for typical presidential compliance with judicial decisions, the bottom line, and I think this is the important point, as Professor Darrell Levinson of New York University Law School has observed, is that, quote, the judiciary can impose constitutional constraints on powerful political actors only if these actors support the judiciary, end quote, either because the public supports the courts or because the politicians themselves do. Professor Keith Whittington of the Yale Law School agrees. He's written that, quote, the court's judgments will have no force unless other powerful political actors accept the importance of the interpretive task and the priority of the judicial voice, end quote. Whittington further notes, quote, political actors defer to the authority claims of the courts because the judiciary can be useful to their own political and constitutional goals, or at least because challenging the court may be too politically costly, end quote. I submit that the U.S. Supreme Court inevitably and within limits properly takes account of circumstances like these in exercising the power of judicial review. What's judicial review? It's the authority of courts in cases properly before them to determine whether the actions of the executive branch, the president, Congress, state legislatures, state executive officials are consistent with the U.S. Constitution. I focus here on the court's protection of its own authority when faced with political threats from the president for reasons I've already identified. That's where the threat is most likely to come from, given the power, given the status of the modern presidency. But it's worth observing that the threat could come from somewhere else. It could come from Congress. It could come from a defiant state or group of states. There are different examples of this throughout American history. The court lacks the sword and the purse, Hamilton teaches us, but it has other tools that it uses to protect itself. And let me mention at least a good number of them before I give you an example. I discuss an episode in which the court used some of these tools. First, the court can avoid deciding, either for the time being or at all. Avoidance of a decision, not weighing in, can be self-protective. And by the way, if this is obscure to you, think about how you relate to your friends. Think about how you relate to classmates who are not your friends. Think about how you relate to your teachers and your family members. Do you always say what you think? Do you always give your opinion? Or do you sometimes think the better course is just to remain silent, not weigh in, let them fight it out, or just be supportive? right? Or be neither supportive or non-supportive, avoiding a decision, avoiding intervening at all. Delay in issuing a decision. Sometimes delay can be a wonderful thing when tempers cool, right? Well, it's not always a good thing as a court to strike when the iron is hot and tempers, right, have been raised. Wait a while, delay in issuing a decision. Gradualism in decision-making. Instead of deciding a huge issue all at once, do it incrementally, one step at a time over a series of cases, which allow people to get used to or accustomed to where the court is headed. Gradualism can be more effective than deciding in one fell swoop all manner of questions that could be coming up or arising. Something that scholars call minimalism or minimalist decision-making. Deciding a matter as narrowly as you reasonably can, as opposed to being maximalist, deciding not just this case, but 100 other cases by articulating some broad legal principle. You can decide narrowly as opposed to broadly. You're much less likely to make a mistake that way. You're more likely to sustain social solidarity. You're less likely to have someone feel like they've completely lost everything. Right? A modern example might be deciding an issue of abortion or gun rights or gay rights or what have you. Right? Not the entire issue, but a piece of the issue, so that both sides feel like they've at least partially been heard and they live to fight again. And by fight, I mean peacefully, through litigation, through social advocacy of their own convictions. Courts have a lot of discretion sometimes in crafting remedies for legal violations. They can craft remedies for violations by political actors in a way that will reduce confrontation with those actors. Some remedies are going to be much more invasive than others. A very broad federal court injunction saying stop doing this at all versus a more incremental remedy like maybe not doing this in this place under these conditions for now in these circumstances, or something other than an injunction, a declaratory judgment, or a damage award. Right? Remedies for the same legal violation can either inflame powerful politicians or cause them to be less likely to go after the court that issued the unfavorable decision. Sometimes the use of dicta, which is language in a judicial opinion that's not strictly necessary to decide the case. The use of dicta or language in an opinion to offer consolation to the losing side, or to plant certain seeds of judicial authority or power for the future. That's another tool of self-protection. Sometimes courts appeal to what scholars call the national ethos, American collective identity, values that we hold in common as Americans, democracy, the Constitution, the rule of law, the role of courts in upholding the rule of law, the importance of settling disagreements in litigation as opposed to, well, which side is the military going to support? Right? That's not how we have, at our best, tried to settle disagreements. The deployment of rhetorical skill more generally, right? Speaking clearly, effectively, in ways that get people to hear you and maybe even listen to what you have to say, as opposed to just putting people off by unskillful rhetoric that just makes them feel attacked. Communication to political actors or to the public outside the context of judicial opinions or orders. That's what the Chief Justice did. Chief Justice Roberts, he illustrated this technique in that rare public statement about the propriety of appealing adverse judicial decisions if you're the government, and the impropriety of impeaching the judges who rendered the decisions. There's also a technique that I call strategic bundling. Strategically bundling decisions or reasoning to include both good news and bad news. News that will be viewed unfavorably by powerful politicians with news that will be viewed more favorably. When I give feedback to my students on their work, right, I try to always have it be constructive, but I also try to include some compliments and not just criticisms, right? The point is to help students improve, not to, right, cause them to lose motivation or to feel dispirited or defeated, right? Well, judges can do that as well. Sometimes when the Supreme Court has told the executive branch, the president, no, you don't have the constitutional authority to do this, it hasn't simply been a no. It's been a no but. No, but if Congress signs off on this, if Congress approves, if the most democratically responsive and representative branch of government signs off on what you want to do, then the answer will be yes. Right? So in the face of Congress saying no or Congress being silent, no, you can't do it. But if Congress signs off, rest assured that we, the judiciary, would approve of the conduct in question. Now, in the most extreme circumstances, these tools include temporary surrender in the face of a political reality that the court regards itself as powerless to confront or affect. I'll give you an example. I think the most remarkable confession of judicial impotence in the corpus of the Supreme Court's work is likely the court's 1903 decision in a case called Giles against Harris. That's where the court, in an opinion by a famous Supreme Court Justice, Oliver Wendell Holmes Jr., a wounded Civil War veteran who went on to become a great professor at Harvard Law School and one of those historic figures who you meet in all your first-year law school classes if you go to law school. Holmes declared for the court that it was powerless to address massive race-based disenfranchisement in the South for the better part of a century in the face of the 15th Amendment's prohibition on racial discrimination in voting, given the inaction of the political branches. And at the time, national opinion, including in the North, approved of the outcome in Giles. The court said an injunction to stop the racism and the racist restrictions on voting in the South is going to do nothing if the president and the Congress won't get in the game. And it's not until Brown and then the Voting Rights Act, a little more than a decade later, that the situation begins to change. Justices are fallible. They're people. And so it's not inevitable that they're going to use the tools of self-protection wisely or effectively to preserve the court's authority. How well the court uses these tools will depend in part on the skillfulness of the Chief Justice, not just on the Chief Justice, but in part. The Chief Justice is the lead spokesperson for the Supreme Court, both internally and externally. And the legacy of a Chief Justice is tied more closely to the overall success of the institution than is the legacy of the individual justices. These considerations mean, among other things, that the Chief Justice is in a special position to help the court the justices overcome their own disagreements and collective action problems. The court's a collective body, and like all such collective bodies, there's going to be a danger that individual members are going to prioritize their own concerns, whether they're legal concerns, ideological concerns, more crassly political concerns. They may prioritize them over the interests of the institution of the Supreme Court as a whole, and an effective, respected Chief Justice can tamp down some of this individualism. As I explained at the outset, one cannot always be certain that the court's using the tools of self-protection as opposed to simply applying the law as best it understands the law. To know what the court or what the court is doing, one needs to know why the court is doing it. One has to discern the motivations of at least the majority of justices, and they may not tell us their motives. They may not actually even know fully their own motives. Do you always know why you do what you do? Right? Sometimes we look back and ask ourselves, why did I do that? Why did I say that? And also, the Supreme Court is a they, not an it. They may not have all the same motives. A majority of justices may be motivated differently depending upon the individual. Now, having said all that, it does seem to me that the current Supreme Court has at times used these tools of self-protection during the second Trump administration. That is to say, instead of doing law all the time, regardless of the circumstances, the court has, like the wise parent, maybe even teacher of a teenager, picked its battles and sought to preserve its institutional authority. Chief Justice Roberts issued that rare public statement, and he took care not to call out President Trump by name. That was smart. Even though Trump is by far the most influential critic of the federal judiciary, and it was Trump's call for impeachment of one judge in particular that prompted the Chief Justice to say what he did. I'll give you another example. In an initial challenge to Trump's controversial use of the Alien Enemies Act, this is a once obscure 1789 federal statute. It was invoked, it's been invoked by the administration, it still is, to remove individuals from the United States who aren't citizens. The court held that the lower court that had restricted what the administration could do lacked jurisdiction or authority to issue relief. So it sided with the administration, while at the same time declaring in dicta, that language that wasn't necessary to the outcome, that the individuals could file their challenges in other courts, namely where they were being held in Texas, and that procedural due process, notice, a hearing, an ability to contest their removal before a neutral decision maker like a federal judge, that required the administration to give all the individuals advance notice of their removals so that they could, in fact, go to court and challenge them if that's what they wanted to, and that they needed sufficient time to be able to do so. Some observers compared this approach to the court's famous 1803 decision in Marbury against Madison, which I will soon discuss. In subsequent orders, including one that the court issued extraordinarily at 1 o'clock in the morning on a Saturday, I can't remember when that's ever happened before, the court made clear by a vote of 7-2 that the individuals being held in Texas, their due process rights of notice and an opportunity to contest their removal, those are real and substantial rights. They're not a mere formality or technicality that the administration could satisfy through last-minute notification in a language that the individuals do not speak. I could give you other examples involving the Alien Enemies Act, but in the interest of time, I won't. I'll simply say I'm happy to take questions about it. I think the administration's invocation of it at all is legally quite dubious. It requires a foreign government either to invade the country or to be responsible for a predatory incursion into the country. The mere existence of alleged gang members from Venezuela doesn't seem to me to satisfy either criterion, and yet to date the Supreme Court has not touched the ultimate question of whether the administration can rely on the AEA at all. It has avoided that big issue for the time being. There may come a time this coming term where it can't avoid it anymore, but it has delayed doing so, and I think that's another example of self-protection in action. And this practice of self-protection has a long history, and I'm going to illustrate that now with this episode from the early 1800s, in which the court used these tools to navigate threats to itself, stand up for the rule of law, and preserve its future legal authority. So let me tell you something about the elections of 1800. Any of you seen Hamilton or know the soundtrack, right? That had more influence, right, than a million law professors. Anyway, I digress. These were the first transformative elections in U.S. history. They led to the first transfer of power from one political party to another. The hitherto dominant Federalists to the Jeffersonians, the Democratic Republicans, which eventually would become the Democratic Party. And this was at a time when the parties despised each other. They viewed each other as a threat to the country and the Constitution. This was also, by the way, the first transfer of power through a democratic election in world history. We take it for granted. We shouldn't. This transfer of power led to some challenges for the Supreme Court. The outgoing Federalists, after they got crushed in the elections, they were led by John Adams. They sought to strengthen their control of the federal courts before the Democratic Republicans, led by Jefferson, took office. And they took various actions to try and load the federal courts with Federalists, with members of their own party. So Adams, in January of 1801, nominates John Marshall as Chief Justice, and the lame duck Federalist Congress speedily confirmed him. For the remaining weeks of Adams' administration, Marshall was serving as both Secretary of State and Chief Justice. On February 13th, the Federalist Congress passed the Judiciary Act of 1801, which ended circuit riding by Supreme Court justices, traveling around the country and hearing appeals in the lower courts, which the justices hated doing. There weren't cars or planes back then. They also, this statute created 6 new circuit courts with 16 new federal judges to serve on them. All these judgeships went to the Federalists. The statute also expanded the scope of federal jurisdiction and reduced the size of the court from 6 to 5, which would have had the effect of denying Jefferson his first appointment to the court. And Jefferson and his supporters were furious. And Jefferson, in private correspondence, invoked military imagery. He said the Federalists have retired into the judiciary as a stronghold, and from that battery, all the works of republicanism, Democratic Republicans, are to be beaten down and erased. On February 27th, a week before the end of Adams' administration, the Federalists turned to more mundane matters. They passed an organic act for the District of Columbia, which created the Office of Justice of Peace in the new district. Justices of the peace would maintain public order and serve for 5-year terms. Adams submitted 42 names to the Senate, all Federalists, and they were all confirmed. One of them was William Marbury, a business person from Georgetown. And by the close of business on March 3rd, the day before Jefferson's inauguration, the Senate had quickly confirmed all the nominees, prompting Adams to sign the commissions into the night, with Marshall literally sitting next to him. And then Marshall sent his brother out around D.C. to deliver the commissions. The Great Seal of the President of the United States were affixed to them. Some of the commissions were delivered, including by James Marshall, John Marshall's brother, but some were not, including for William Marbury, poor William Marbury. They were discovered at the State Department when Jefferson took office the next day, and he prohibited the delivery of these commissions. More significantly, on March 8th, the Democratic Republicans in Congress repealed the Judiciary Act of 1801, removing the 16 new circuit judges from office by eliminating their courts, notwithstanding Article 3 of the Constitution's provision of life tenure, that is, service during good behavior for federal judges. Congress also increased the size of the court back to 6. So after the Federalists unpacked the court, right, the Jeffersonians responded by bringing it back to 6. Then Congress passes the Judiciary Act of 1802, which restores circuit riding by the judges, by the justices. And the Jeffersonians understood that the former circuit judges might challenge the constitutionality of the Repeal Act by arguing that, constitutionally speaking, there was no difference between removing the judge from the court and removing the court from the judge. And so what did Congress do? They delayed and deterred any Supreme Court decision on the matter by canceling the Supreme Court's June term, which postponed the court's next meeting for almost a year, until 1803. This is what we call today constitutional hardball, first by the Federalists and then by the Democratic Republicans in response. The House of Representatives also initiated impeachment proceedings against a Federalist judge, John Pickering of New Hampshire, and the Senate convicted him and removed him from office. By itself, that wasn't necessarily such a big threat because, as a political historian, Robert McCloskey described Pickering, he was hopelessly insane and a drunkard, meaning there were good reasons to remove him from office, not just political disagreement. Nonetheless, Marshall and his colleagues were well aware that they might be next on the chopping block, that they might be impeached and removed from office based on political disagreement with them and their decisions, starting with the combative partisan Federalist Justice Samuel Chase. Marshall was so worried about the court's survival in this world that he astonishingly wrote in private correspondence that he would prefer to have Congress be empowered to overrule Supreme Court decisions it didn't like than have the justices be removed from office through impeachment. I have a letter from John Marshall saying, I'd rather have Congress exercise appellate jurisdiction over us. That's such a huge, big deal that I think very few people know about. That's how worried he was about him and his colleagues being impeached and removed from office. He offered this idea even though there was no proposal to do this circulating in Congress. So in this tense environment, everyone watched to see whether the justices would risk a constitutional crisis and removal from office by holding in a case called Stewart against Laird that the Repeal Act, the one that got rid of the new circuit judgeships, contravened Article 3 of the Constitution, the good behavior clause in the Constitution. And the justices, when they eventually heard the case, made clear that they would not. The court surrendered to political reality by unanimously upholding the Repeal Act in an opinion spanning only 4 paragraphs by Justice William Patterson that did not address whether terminating federal judgeships by terminating courts violated Article 3. The court didn't address that issue that was squarely before it, rather than expressly endorse the Jeffersonians' likely violation of Article 3. And by likely, I really mean almost certain violation of Article 3. The court wrote as if all that was at issue was Congress's decision, which the court approved, to transfer the case from the circuit court created by one judiciary act to the circuit court created by the other. No big deal, nothing to see here. In short, the court in Stewart against Laird acquiesced in giving effect to the constitutionally questionable Repeal Act, and it almost certainly did so because it viewed itself as having no reasonable choice. They were worried about being impeached and removed from office if they actually held the Repeal Act unconstitutional. Marshall, frankly, was powerless to confront directly the constitutionality of the Repeal Act. And so you see the court using tools of self-protection, but not simply endorsing what the administration and the Congress had done. Neither party cared nearly as much about perhaps the most famous case in all of constitutional law, Marbury against Madison, from the same year, in which the court declared for itself the power of judicial review. Nonetheless, litigation began over the matter in 1801 when Charles Lee, a Virginia Federalist, filed suit on behalf of Marbury and 3 other individuals who didn't receive their commissions, and he filed it in the court's original jurisdiction, where the court can hear cases as an initial matter, as opposed to appellate jurisdiction, where it hears appeals from the lower federal courts. And Lee asked the justices to issue a writ of mandamus to compel Jefferson's Secretary of State, James Madison, to deliver copies of their commissions to Marbury and the 3 other appointees. A writ of mandamus is an order from a court to a lower court or a government official to comply with a non-discretionary duty, a mandatory duty, an obligation pertaining to the office that the individual holds. And writing for the court, John Marshall found a way both to assert the court's authority and to avoid the political threat. The administration would almost certainly have ignored any judicial order to deliver the commissions. The administration didn't even show up to the Supreme Court to argue its side of the case. And that really would have exposed the court's institutional vulnerability. And as I've mentioned, impeachment proceedings against Marshall and his colleagues were quite possible. And so the issue facing the court was not who should win. Frankly, the administration had to win. Marbury had to lose if the court was going to survive. But how Marbury should lose? Should the court grant the administration a complete victory? Or should it have Marbury lose while still offering consolation to him and fellow Federalists, the federal judiciary, and the rule of law for which the court was responsible? Marshall, in his oddly organized opinion, succeeded in bowing to the inevitable while still standing up for Marbury and the court itself. Marshall concluded that although Congress had given it the authority to hear this case, Congress had violated the Constitution in doing so. The court lacked authority or jurisdiction to decide the case for complex reasons I don't need to get into right now, but I'm happy to talk about during the Q&A. But before getting to the issue, Marshall went out of his way to decide the merits in a way that was favorable to Marbury, saying he had a right to his commission, the law gives him a remedy, and a writ of mandamus is an appropriate remedy. So the court decides the merits and then says it doesn't have authority to decide the merits. That's not how courts behave today. Jurisdiction is fundamental. You first decide whether you have authority, and then only if you do you decide the merits of the case, who wins and who loses. Marshall did the opposite here. And in doing so, he refused to apply a federal statute for the first time, saying the statute which gives us the power to decide this case is unconstitutional. We can't do so. That planted the seeds of judicial authority for the future in a context in which there wasn't going to be much pushback against the court. After all, the administration wins. So why would the administration care if the court said in dicta, by the way, we have the power of judicial review to set aside acts of Congress and the president? And in future cases, they're going to say the states too. And so he plants the seeds of judicial authority for the future in a context in which there's not going to be much blowback or pushback or backlash against the Supreme Court. Now, most commentators have concluded that Marshall's opinion is not a model of legal craft. It's shot through with vulnerable legal reasoning. Again, I'm happy to go through it if you want. But what I want to emphasize here is that it's true that one can make lawyerly objections to Marshall's reasoning. I do it in the basic constitutional law course that I teach. I do it in the federal jurisdiction course that I teach. But it's also the case that lawyerly objections to Marshall's reasoning that don't take any account of the political context in which he was reasoning miss the broader picture. After Congress imposed a substantial delay on the court's issuance of a decision, thereby obviating any need for the court to itself impose a delay, Marshall recognized the political limits on the court's authority and held that it lacked authority to decide the case. But Marshall didn't simply have the court roll over and play dead. He used the power of dicta to underscore that this court was not endorsing the Jeffersonians' condemnation of the so-called midnight judges, those who had been appointed at the last minute as the clock was striking midnight on the Adams administration. Moreover, the dicta in Marbury didn't provoke a political backlash. Marshall also declared that the court possessed the power of judicial review. Robert McCloskey, a famous political historian, described Marshall's opinion as a masterwork of indirection, a brilliant example of Marshall's capacity to sidestep danger while seeming to court it, to advance in one direction while his opponents are looking in another. And as the crisis subsided, the Supreme Court remained alive and relatively well. What had been most required, Professor McCloskey observed, was a measure of present judicial self-restraint. Now, it's true that the Repeal Act could have set a dangerous precedent for getting rid of federal judges who are supposed to have life tenure by simply getting rid of their courts. But the court became stronger after this controversy and thereby put itself in a better position to resist similar future efforts. And partial proof of the wisdom of the court's approach occurred on March 1st, 1805. That's when Justice Chase's impeachment, he was impeached, it failed in the Senate. And as Professor Charles Warren wrote in his History of the Supreme Court, which was published in 1922, this was one of the signal events in the history of the federal judiciary. At a time when it was unclear what an impeachable offense was for a federal judge, Chase's acquittal suggested that federal judges could not appropriately be impeached and removed based on a disagreement with their opinions or because members of Congress viewed the judges as political adversaries. And we've stuck with that understanding ever since. I find it deeply illuminating that Marbury against Madison, the famous case in which the Supreme Court claimed for itself the awesome power of judicial review, based on what the court asserted is a strict separation between law and politics, as well as the function of the Supreme Court to say what the law is, that's quoting Marbury against Madison, is in fact a case in which the court played a self-protective form of politics to preserve its future practical ability to speak the language of law to the exercise of political power. It has almost always been this way. Judges who are moved by the movement to say, we do law, not politics, are characteristically doing a certain form of politics, not law. And I think that's a nice place to conclude, and I look forward to your questions.
Thank you so much for that, Professor Siegel. I will be asking several questions that we've collected in response to your prepared comments. Thank you so much. Can we thank him one more time for his presentation? So allow me briefly to introduce myself. I'm Colby Reddish. I live and practice here in Boise, Idaho, and practice currently for the state's Occupational and Professional Licensing Office. One question I wanted to ask you is a lot of your comments today revolve around the word politics and how the court engages in this self-protectionary political actions. Can you maybe speak to the difference you see between politics and partisanship, especially for our students here? They likely hear the word politics most associated with partisan battles. Can you maybe speak to that?
Yeah, it's a wonderful question, and I thank you for asking it, because we lawyers, we legal scholars, we judges in the United States, we journalists who follow the courts, we do not have very good resources for talking about the different ways in which judges may occasionally act politically. We have this model in which there are only two modes. There's law, and then there's everything else, and everything else is politics. And then we often hear politics simply to mean partisan politics. I'm not talking about partisan politics, even though in the example, partisan politics was implicated, Federalists and Democratic Republicans. But that's not what I'm talking about. I'm not talking about how did Marshall act in a way to maximize the survival chances of the Federalist political party, which, by the way, ends up getting destroyed right after the Jeffersonian victory. I'm not talking about John Roberts. How is he maximizing the chances of the Republican Party today? That's not what they're doing, right? By politics, one could mean partisanship. How can we advance the fortunes of a political party? In my view, it's an impeachable offense for a judge to base a decision, at least in part, even in part, on partisan considerations. Their robes are black. They're not red. They're not blue. Right? That's an important point. So I'm not talking about partisanship. I'm also not talking about ordinary policy preferences or ideology. That sometimes is used as political, like political ideology. I think when it comes to the U.S. Constitution that has a bunch of language we all care about that's written at a high level of abstraction and generality, liberty, equality, due process, commerce, speech, unreasonable searches and seizures, right? I think it's inevitable that different ideological commitments or worldviews are going to inform constitutional interpretation. That's not what I mean either, politics as ideology or worldview or views about fairness, justice, right, policy matters. I'm talking about what you could call a kind of institutional politics. I'm talking about the political foundations of the authority that courts have, the political foundations of the rule of law, that when judges decide cases, it's not magic that causes people to obey, right? There has to be political support for the judiciary. Not when people agree with the courts, then it's easy, because they're doing what you want. It's when you don't agree. Right? That still causes you to obey if you're a president with a lot of power at your disposal, and you still obey, you still comply with the judicial order. Why? Right? I think part of the explanation is not just how presidents and other politicians have behaved, it's how the Supreme Court has behaved in the face of those threats. And there's a certain kind of institutional self-preservation politics that I'm talking about. It's not politics as ideology. It's not politics as partisanship. It's focused on the survival of the institution, which it needs to survive in order to say what the law is. People who say, justice, justice, thou shalt pursue. It's a famous phrase in Hebrew that I grew up with, right? Though the heavens fall. Well, guess what? If the heavens literally fall, there won't be any courts delivering any justice at all, right? And so you actually need, whether you're trying to survive in high school or survive as a judicial institution, right? You actually have to practice a certain kind of self-protective politics. You can't be taking on every fight all the time, right? You have to mind the environment in which you're operating.
Thank you. You mentioned political foundations, and one of the things I think we can see in the work of the framers of the federal Constitution is that they had a strong belief in public education and in an educated populace, and in particular civics education. Can you speak to whether the political foundations you see as a requirement for the court's legitimacy include public understanding and acceptance of the rule of law as a concept? And then the second part of this question is, can you also speak to how you believe today's media coverage of judicial decisions either does or does not provide adequate information for the public about rule of law concepts?
Yeah, I mean, the first question, right, it's worth underscoring that I addressed it in part of my remarks when I gave reasons why powerful politicians, especially presidents, comply. Right? It's either their own internalized obligation to obey, they feel an obligation to comply, or because the political costs of noncompliance are high. Well, the reason the cost might be high is because Congress is upset or because the public is upset. I think if this administration, right, just flagrantly defies a Supreme Court decision, I think the public's going to be upset. I pray that they will, no matter who the president is. Because if an administration can defy a Supreme Court decision, there's no appeal from the U.S. Supreme Court. I think it's a problem to defy lower court orders, a real problem, but at least there's an appeal. After the Supreme Court, the question is literally who is the military going to side with? Then the law has run out. Then we're in a constitutional crisis. We have managed, for the most part, to settle deeply held disagreements over fundamental values nonviolently without resort to the military. There are all kinds of countries around the world in which that's not true. And they either don't have courts or the courts they have are completely politicized courts in the sense that the authoritarian who actually runs the country tells the judges what to do, and they had better do it if they know what's good for them. Although they'll end up removed at best or dead at worst. So yes, public support for the judiciary, public support for the rule of law is essential. Presidents, members of Congress, governors, state legislators need to know that it's a problem if they defy judicial rulings, if they defy judicial orders. Better to have it be decided through that process nonviolently than through the alternative. Now, in terms of media coverage, your second question, I mean, the media, like this, the media is a they, not an it, right? I mean, and when I was growing up, there was CBS, ABC, NBC, and public TV, and we all got our news from the same place. And frankly, there are great things about social media and the proliferation of media today, but there are also real costs. I mean, Americans don't have a common foundation in fact about what's going on. We used to have a fancy way scholars would put it is democracy requires a common epistemological foundation, blah, blah. What that really means is that we can at least agree on the basic facts of what's going on. And Americans mostly used to hear news from Walter Cronkite, from this, and yeah, there were voices that were left out, and I'm not saying there was no problems with it, but we didn't disagree about what basically happened, and we disagree all the time about what the facts are. And I think that can really undermine a democracy because some really threatening, really unlawful behavior can be publicly justified as, far from it. That's not what we're doing at all. Now, the media has become politicized. It's become partisan. I think there are more or less trustworthy organizations. I'm not going to tell you what I think they are because then that's going to be viewed as a political statement. That's the world we're living in, right? It's not possible to name a news source that is not going to be viewed as partisan or divisive. So I think that's a real problem. I mean, to be most directly responsive to your question, does the media help things or hurt things? You know, it depends on who you listen to. I think there are responsible journalists out there. Those are the ones I'm willing to speak to, because I know they're not going to misquote me or take things completely out of context, although I have learned to not let them use anything. Everything is off the record. If they want to use anything, they got to share it with me first, because I've been misquoted too many times. So I think that's, but there are reputable journalists who follow the courts. Do most people follow that, or are most people, you know, I don't know, on TikTok? I think it's sort of maybe we get the media we deserve. I think that's not entirely fair, because I think the media also needs to play a leadership role, just like judges and politicians do. But I do worry about how the work of courts is conveyed to the public through the media, which is really important, because most people don't read judicial opinions. They're living their lives. They don't have time. And so what the media says about the courts, I think, is important.
Thank you for that answer. As a former chair of Attorneys for Civic Education, I'd be remiss if I didn't mention the first of our presentations back several years ago actually centered exactly on social media and on this question of how the media responds to judicial action. My next question relates to your comments about increased threats, either political threats or actual overt threats of physical violence against judicial actors. On Friday, the Idaho Supreme Court actually issued, again, sort of a rare occurrence, a press release relating to threats made to one of the members of our local judiciary for a decision it had rendered in a case that was unpopular in response to some would say misinformation about the reporting of what happened in that case. My question for you is how members of the public who care about the rule of law, who care about supporting having a strong and independent judiciary, can address situations like that.
Yeah, I mean, the threats I've talked about are things like impeachment, having your jurisdiction stripped, or having your court packed. But there are, you know, threats of physical violence that judges, federal, state, and local, live with day in and day out. And, you know, every now and then, a judge and their family, right, they end up getting murdered. And so, you know, one of the main reasons I go around the country talking at state judicial conferences is because I think those judges are the unsung heroes of the judiciary in the United States. They're not going to become rock stars like, you know, I think it's really unhealthy that Supreme Court justices can achieve this kind of cult status. And it's not like, you know, these judges in all the different states are getting paid so much money and that's why they're judges, right? I mean, it's really a public service that is often not sufficiently appreciated, and they live with threats of violence. And I know this because of the judges I teach and the judges I work with and the judges I send students to for clerkships, right? They live with these threats, and they worry about themselves and their families. What I would say is, and maybe what I should have said about your question about the media is, you know, don't believe everything you read, and so much media reporting doesn't leave room for nuance. I mean, the main reason I stopped writing op-eds is because they don't want nuance, right? Opinion editorials, you know, take a view and write it all the way, you know, and I'm a sort of on the one hand, on the other hand kind of, that's why I ended up doing what I do, right? As a scholar, as a teacher, as a judge, right? As a thoughtful lawyer, you live with nuance. You live in the details. They matter. It's not just pro or anti a certain issue. And so, you know, be skeptical about what you read, dig into it, read more than one source of information, force yourself to read sources of information that are, you know, have an ideological valence or reputation that's different than the one you're most comfortable with. Very few people do that anymore. Try and be friends with people who you disagree with. Try and have them in your lives. I mean, we're geographic. I mean, partisanship now is geographic. Right? We less and less live with people who think differently. And so that's what I would say, is be an intelligent, informed consumer of information about the courts, the legislatures, what they're actually doing. And frankly, whatever the nuances are, right, violence has to be completely out of bounds. I think some of the most alarming public opinion polls that I see is sort of the percentage of the population that believes that political violence can be justified, right, under various circumstances, if going about things through elections or judicial decisions doesn't get you your way, right? So whatever the nuances are, it's not, oh, I wouldn't have brought my rifle if I had known the actual facts. No, don't bring your rifle, right? If you disagree with the decision, vote for a different judge, write an opinion editorial, vote, participate in public life. But you know, that road leads nowhere good.
In line with that question, I appreciate your advice, especially to the high school students we have, about thinking critically about what they hear about the judiciary. If you could give them one tip on how to do that, how to think critically, how to seek out the best information on those issues, what would that advice be?
Yeah, I mean, there are, I think some news sources are better than others, but you have to be willing to consult them. Ask your teachers, ask your family, ask your friends. Look yourself at different sources. What seems not the most ideological or the most partisan, right, or the most telling you what, you know, you really want to hear about an issue, but what seems like is doing a good nuanced job of presenting the issue in a relatively impartial way and trying to give at least both sides, and consult them. There are SCOTUS blog is you know a really good private blog that covers the U.S. Supreme Court. It's so good that they use it inside the court, because SCOTUS blog knows where they're, you know, where the people who come to them come from, and you know, the justices and their clerks routinely consult SCOTUS blog. They didn't have that when I was clerking there. But that's a great example of a place I go for information about what the U.S. Supreme Court is doing. There are also, you know, there are more libertarian blogs, there are more progressive blogs, there are more, you know, there are different blogs. If you know the ideological valence, then, you know, that's fine. You know where it's coming from. Consult a variety of them. Look at the news coverage of you know, mainstream newspapers. Know the difference between a news article and an editorial. If you're really interested, start looking at some judicial opinions. You can't do it all the time, but if you have a real interest in executive power, if you have a real interest in administrative agencies or in various issues of individual rights, the court issues opinions, you could read them. The best justices write in a way that's readable to the public. You could read some of these opinions, not just read about them, and judge for yourself. I think that's another nice way to go about it. I'm wondering if there are any students who might be interested in asking questions. It's I have never bitten a student, I promise. There is a 0% chance.
I make no such promise.
Yes. Yes.
Yeah, please come up here.
So earlier you mentioned different rights that can be violated by, you know, some judicial power or another, and that will lead to political disagreement. I was wondering, from a legal opinion and stance, what your view would be on abortion, and if it violates our natural rights, and if it is not defended, if that would be a violation of the Constitution.
Okay, are you asking whether, are you asking about the status of the abortion right? Or are you asking about the status of the Constitution? So when we talk about abortion, right, so there are different, one possibility is that there are no constitutional rights involved at all. That's the Supreme Court's current stance in the Dobbs decision, which overruled Roe and Casey, that the issue is left to the political process. It could be a matter of state constitutional rights, but as far as the U.S. Constitution is concerned, the Constitution is neutral, the court should be neutral, the political process decides, right? Another view which prevailed while Roe was the law and then Casey was the law is that pregnant women have rights to abortion under certain defined circumstances that the courts need to be prepared to protect. And over time, the court continued to do that while also lowering the level of scrutiny with which the courts examine the right, allowing a lot more regulation than it used to. A third position is that, in fact, the constitutional rights that are implicated are those of a human fetus, that the word person in the 14th Amendment refers to the fetus, and the implications of that view, which the Supreme Court has not adopted, would be that abortion is not constitutionally permissible, that it's constitutionally prohibited. Right? So those are the range of possibilities. The court has taken two of those views. The third one it has not taken, although there have been groups who certainly believe that life, not just for religious purposes, but for constitutional purposes, begins at conception. So abortion under any circumstances, or almost any circumstances, is unconstitutional. There are a range of views one could have, and they can actually become quite nuanced. And I think the median member of the American public, the view is actually quite nuanced. It's not sort of yes, no. It's not, always one way or the other. What about, if there's a threat to the pregnant individual's life, right? What about rape or incest? What about severe fetal deformities? What about, going to a state in which abortion is permissible, right? So there are a variety of views one could have. And the Constitution itself, I don't think the text speaks clearly to the issue. I think the court's views have changed over time in response to a significant extent to changes in the court's composition.
All right, thank you.
You're welcome. Others, come on. What do you have to lose? Yes. I'm an admirer of Kermit.
It's Adam Sandler Day at Boise High.
What's that?
It's Adam Sandler dress-up day at Boise High.
Oh, is it?
Yeah.
I'm also a fan of Adam Sandler, although I could give you a lecture on my favorite Adam Sandler movies, but go for it.
Okay, so I think it was in Federalist 51, they were talking about how factions are dangerous because they infringe upon the rights of other people, and you can't have a right that also hurts someone else's. And I wonder how the Constitution and the Supreme Court can defend gun laws when it's very clear that owning a gun and using it as a weapon infringes on people's right to life.
Mm-hmm. Right, so this is we talked about the constitutional status of abortion. Now we're talking about the constitutional status of gun rights. And, Madison's approach in Federalist 10, which is he defines a faction as inherently bad, right? As you stated it accurately, right? A faction, right, is a group of citizens, whether amounting to a majority, minority, or the whole, who are united and actuated by some common impulse or passion adverse to the rights of other citizens or to the permanent and aggregate interests of the community, right? So one possibility is they're just doing stuff that's bad for the community. Another possibility is they're violating individual rights. And his basic solution was get better representatives and have a larger, more diverse republic in which the factions will cancel one another out. In order to get stuff done, we'll have to come to some kind of compromise. And that's not a terrific solution. And he, in fact, ended up believing in judicial review and courts protecting rights because it wasn't a great solution. In fact, most of the other framers, Federalist 10 is famous in modern times, but most of the other framers didn't actually understand what Madison was saying, and they didn't necessarily agree with it. That's beside the point. All right, so the basic strategy we have for protecting rights has not been extending the sphere and having this large, diverse republic. It's been judicial and legislative interpretation of constitutional provisions and principles that protect rights, like the Second Amendment. And the Second Amendment, its proper interpretation is controversial. It starts off in a purposive or prefatory clause by saying a well-regulated militia being necessary to the security of a free state, which seems to suggest that's why we have the Second Amendment. The purpose is a well-regulated militia. It has nothing to do with individual rights to keep and bear arms. But then you read on and it says, the right of the people to keep and bear arms shall not be infringed. And that sounds like an individual right to keep and bear arms, at least under certain circumstances. How you connect the initial purposive clause and what's called the operative clause that seem to be in some tension with one another has led to a lot of disagreements. The answer to your question, right, in short, is interpretation of the Second Amendment, but I want to acknowledge that the proper interpretation of the amendment is controversial. Until 2008, until a case called Heller, the Supreme Court said, we're leaving it to the political process. This is not an individual right. The Second Amendment reflects what's called the collective right of the people to have arms if they're serving in the well-regulated militia, which became at one point the National Guard. It's not an individual right to keep guns in the home or carry them for purposes of self-defense. In Heller in 2008, as the court becomes more conservative, interprets the Second Amendment to protect an individual right to keep and bear arms, at least in the home. Then 2 years later in McDonald, it applies that right to the state and local governments. And then more recently in the Bruin decision, said that this right extends outside the home to keep and bear arms for purposes of self-defense. And so the argument of gun rights advocates, as well as the current view of the Supreme Court, is yes, firearms can be used to harm other people, but they can also be used for other purposes, including self-protection, self-defense. That is a complex policy disagreement in which I wish facts and evidence mattered more than they do to most people. The legal question has to do with the proper interpretation of the text of the Second Amendment, of its history, of the debates out of which it arose, of past judicial decisions and how the court has interpreted the amendment. I think you're right that firearms are unique as rights go in terms of their capacity to inflict lethal harm, but they're not unique. Right? We protect a lot of speech that you can bet is also going to provoke harm to people, and in some cases, violence. And unless it's a provocation to imminent lawless violence, that speech is going to be protected. We protect speech to an extent that other countries in the world think is just nuts. We're a very speech-protective nation, and speech can cause various harms. Now, I'm not going to say that that firearms, which I'm very familiar with, I grew up with them, that kind of lethal force, that's nothing like the muskets they had back, when they were debating the Second Amendment, right? I'm not going to say that's just like words, but I do think it's the case that the Second Amendment is not the only situation in which there can be competing rights claims.
How is it fair to the people of the U.S. when the court doesn't maintain that continuity between changing and interpreting the laws? How do they get away with doing that?
Right. So I think you're asking. The law is a balance between continuity and change. None of us would want the Supreme Court's interpretation of the Constitution to always stay the same, because then you have egregiously wrong decisions that have caused terrible harm.
But in such short periods of changing of their minds.
Yeah. When the court's composition changes in decisive ways, meaning now you have 5 justices with a different view, that's when the law tends to change. And I myself would rather see the court proceed more incrementally as opposed to changing things a huge amount overnight. They have been reasonably incremental with respect to the Second Amendment. They changed everything overnight with respect to abortion. It depends on the issue, who the justices are, how strongly they care about the issue. But you're talking about the institution of stare decisis and how the court approaches its own decisions when it disagrees with them. And I haven't written a lot about it because it's really hard. Everyone agrees that stare decisis, respect for precedent, is really important, except when it's not. And then we disagree about when it's not. And we talk about things like, well, has the law changed? Have the facts changed? Have there been changes in technology? Right? Have values changed? But it is the case that the current views of the majority of justices on an issue they really care about tends eventually to become the law, even when they're changing the law significantly, even when it's over a short period of time, and even when a majority or a supermajority of the country disagrees with them. That's part of what their commission authorizes them to do. But whether it's the right thing to do or it's wise to do, I think are the questions that you're getting at. Yeah.
Thank you.
But God willing, we're not at the end of history, and this court does not have the last word. right? Because I felt bad when my clerkship ended and I had to leave, and I'm like, the justices get to stay. It was the hardest job I ever loved. But you know what? They don't get to stay either, right? Their time comes to an end. It's not after a year-long clerkship. It's after a much longer time than that.
We do have more students lined up. Students, if you'll just have a seat, I'm going to close this out for our online participants, and then hopefully Professor Siegel can answer your questions offline. I did have one last question, and then we'll thank you. Let's say on your way out of the Capitol today, you stumble across a very civically minded genie that allows you to add one amendment to the federal Constitution to either solve or head off contemporary or future political problems you see down the road. What would that amendment, at least in purpose, look like, and why?
Yeah. So I don't know that your folks are going to love the answer. And I can tell you the senators from Delaware who I've worked for on Supreme Court nominations aren't going to like the answer either. But I would say to make the Senate, I thought a lot about this, which amendments, right? I would say to make what Madison had originally wanted. This was a hugely divisive issue at the Constitutional Convention, to have the Senate be constituted like the House of Representatives, to have the Senate be more democratically responsive to the population as a whole, as opposed to equal state representation in the Senate. And then the Electoral College is parasitic on the composition of the Senate. And so I think small population states, I mean, you know, back at the time of the founding, the largest population state had something like 12 times the power of the smallest population state. Now, the difference between California and Wyoming is like 65 times in terms of the voting power of someone in Wyoming. So now, but this is a deep issue that goes to what's the, you know, what is the basis of the union? Are we a union of individuals? Are we a union of states? Are we a compromise between the two? But that's what I would say, is to make the Senate substantially more democratically responsive to the population as a whole, and therefore the Electoral College, which represents the president as well. And I think our deepest dysfunctions have to do with how democratically responsive our national political institutions are.
Thank you, Professor Siegel. On behalf of the Attorneys for Civic Education, the Idaho Law Foundation, I want to thank our partners at Idaho Public Television for broadcasting this for us. Thank you, Professor Siegel, for being here. And I want to thank each of our participants. The Constitution begins with the concept of we the people. The more you understand this document, especially for our students, the more that you're able to apply it and be part of this civic-minded experiment that we're all a part of. So thank you so much. Join me in thanking Professor Siegel.